Good morning, this is your Kelso Report for Friday, September 28th, and I'm your host, Clark Kelso. This morning we have cases dealing with briefing requirements in a motion for summary judgment, the definition of public funds for purposes of a criminal charge of misappropriation of public funds, the use of equitable subrogation to reorder priorities for security for a debt, and the scope of restitution in the juvenile justice context. The Ninth Circuit didn't have any opinions released yesterday, so today all of our cases are from the California Court of Appeal. Well, we begin with summary judgment briefing. Now, sometimes the failure to follow a process rule will be forgiven or can be cured. Other times, however, a process rule is of such importance to the judicial process that the failure to follow the rule can be the basis for losing the case. One of those really important process rules in California State Court is that the opposition to a motion for summary judgment must contain a separate statement of disputed material facts. This separate statement helps the court focus its attention on what is really the dispute between the parties. According to Section 437C of the Code of Civil Procedure, a failure to include a separate statement of disputed material facts can result in the court ruling against the litigant on that motion. And that's a dispositive motion, as you know. In Batars v. SEIU Local 1000, that is exactly what happened. The plaintiff had alleged causes of action for racial and gender discrimination, among other things. SEIU filed a motion for summary judgment and its own separate statement of material facts supporting that motion. The plaintiff filed only responsive briefs and did not file a complete separate statement of facts disputing SEIU's assertion of an affirmative defense. At a hearing on the motion, the plaintiff conceded that his separate statement was defective and asked for a continuance to cure the defect. Well, the Superior Court denied that request and granted summary judgment in favor of SEIU because of the plaintiff's procedural default. This left the plaintiff with a long-shot appeal, where he tried to show that the trial court had abused its discretion by failing to grant a continuance in order to permit him to file a proper separate statement. But the plaintiff had no justification or explanation for his failure to comply with the requirements of Section 437C, and the Fifth District found no basis for concluding that the trial court had abused its discretion. Judgment for the defendants. When a government entity distributes money to a private, non-profit organization that operates a group home, does the money become private money in the hands of the nonprofit, or does it retain its character as public monies for purposes of the crime of misappropriation of public funds? Well, that was the question for the Fourth District in People v. Johnson. The trial court in the case had dismissed all 24 counts alleging misappropriation of public funds because the nonprofit was not a public entity and the individual defendants were not public officials. However, the Fourth District reversed. Section 424 of the Penal Code provides each officer of this state or of any county, city, town, or district of this state, and every other person charged with the receipt, safekeeping, transfer, or disbursement of public monies who misappropriates the funds is punishable by imprisonment. Well, the Fourth District reasoned that the defendants did not need to be public officials, because under the language of the statute, they certainly were, quote, other persons, close quote, who had received public monies. The key question for the Fourth District was whether the funds distributed to the nonprofit were still public monies after they had been distributed. Interestingly, the court answered yes to this question, focusing on the fact that the government agency closely monitored how the funds were accounted for and spent, and required that any unused funds be returned back to the government agency. Now, I think this is a pretty close case, and the 4th District has given Section 424 about as expansive an interpretation as it could. The statute appears on its first reading really to be focused on public corruption, not on corruption by grant recipients. And the 4th District's interpretation would appear to put virtually every recipient of government grant funding at some risk. So we'll see if the California Supreme Court decides to take this case up for review. Very interesting holding, nevertheless. Next, we turn to the doctrine of subrogation. This is equitable subrogation is a remedy where one party, for reasons of fairness and equity, steps into the shoes of another party insofar as their rights are against a third party. In our case, MP Morgan Chase Bank versus Bank of America Practice Solutions. In our case, which is JP Morgan Chase Bank versus Bank of America Practice Solutions, Chase Bank had made a loan to John and Julie Seams to pay off their first and second deeds of trust on their residence. Chase had intended its loan to be secured by a new first deed of trust, and its escrow instructions specifically forbade disbursement of the funds if its deed of trust would not be in the primary position. Well, at the same time, and unbeknownst to Chase, Seams also sought a business loan from Bank of America Practice Solutions. Now, while that loan was primarily secured by the personal property assets of John Seams' medical practice, it was also to be secured by a deed of trust on the Seams' real property. Bank of America, knowing that the real property was already secured by first and second deeds of trust, had expected that its loan would be secured by a third deed of trust on the real property. Now, as it turned out, when the Chase and Bank loans were actually funded, Bank America obtained and filed a deed of trust before Chase, which gave Bank America priority. At that point, Chase sought and obtained an order in the Superior Court placing its deed of trust in a position of primacy over banks under the doctrine of equitable subrogation. Bank appealed. Well, the 4th District easily affirmed here, since equitable subrogation provided both parties with exactly what each had anticipated in making their respective loans. Bank of America had no equity in being the first priority on that deed of trust, and Chase did. So they got to step into Bank of America's shoes as the lender with the first priority. Finally, we turn to restitution in a juvenile justice context. When an adult is sentenced, or a juvenile court adjudges a minor to be a ward of the court should also be entering an order of restitution to benefit the victims of the crime. But, as shown by the 2nd District's decision in Re Scott H., the scope of restitution in the adult context is broader than in the juvenile justice context. In particular, in the adult context, the court can enter restitution order not only to the direct victim of the crime, but also to benefit derivative victims who have suffered some economic loss as a result of the crime. In the juvenile justice context, by contrast, the statutes generally authorize restitution only to the direct victim. Now, because of this difference, for example, the direct victim's family is not authorized to receive restitution for expenses that immediate family members may have incurred for mental health services in the juvenile justice context. It's different in the adult context. There, immediate family members can recover those expenses. Well, recognizing this statutory difference, the 2nd District in Re Scott H. reversed the Superior Court's order, which had directed the ward to pay restitution for mental health services that had been received by the victim's family. I can imagine here that victims' rights groups may now approach the legislature with this case in hand to ask why the scope of restitution in the juvenile justice context is so much narrower than restitution in the adult criminal context, since it is at least arguable that the scope for restitution should be the same. That's it for today's Kelso Report. Have a great day in the law.